The United States government has three branches: the legislative, executive, and judicial. What role should each of them play when it comes to military conflicts? There are a number of provisions in the Constitution that could be relevant to this. One of them is the long list of congressional powers set forth in Article 1, Section 8. The 11th thing on that list says Congress has the power to declare war. That list of powers also says Congress has the power to provide for the armed forces, like the Army and the Navy, and to make rules for the government and regulation of the armed forces, and to call out the militias when necessary. And Article 2, which is about the executive branch, says that the president is the commander-in-chief of the nation's armed forces. So when it comes to military matters, what powers does Congress have? What power does the president have? And should the courts play any role? These are essentially separation of powers issues, and they were discussed in the Supreme Court's decision in United States versus Curtiss-Wright Corporation. This was a very important decision. It's controversial and often criticized, but it still gets a lot of attention in this area of constitutional law. Justice George Sutherland had already laid out a lot of the views that he expressed in his opinion in this case, long before the case came along or even before he was a judge. Sutherland had been a member of Congress. He served in the House of Representatives and then the Senate. And in particular, he served on the Senate Foreign Relations Committee, so he was involved and very interested in foreign policy matters. He even wrote an article and then a book that contained all of the arguments and ideas that later went into his opinion in the Curtiss-Wright case. So it was something to which he'd already given a lot of thought, and he was happy to be able to put it all in a Supreme Court opinion. One person described that opinion as a muddled law review article wedged with considerable difficulty into a Supreme Court opinion. This case arose because there was a war going on in South America between Bolivia and Paraguay. There was a region in between the two countries, and both countries claimed that it belonged to them. For a long time, there was a dispute over it, but nobody really cared that much because the disputed area was a horrible place. Most of it was a very dry desert. The rest of it was a dismal swamp full of stinging insects, poisonous snakes, tropical diseases, and piranha fish. So for the most part, neither country was particularly worried about the area. But then in 1928, everything suddenly changed because there was oil discovered on the edge of the region. And suddenly everyone suspected that there might be a lot of oil under this desert. So both countries now really coveted the territory. And the American oil companies got involved. Standard Oil, the giant company founded by John Rockefeller, was aligned with the Bolivians. And Shell Oil had close ties to Paraguay. And so the two countries, with some prodding from the oil companies, eventually went to war over this. And it was a terrible war. Both sides had a lot of casualties.
Paraguay sends reinforcements to the Gran Chaco, planning a new offensive against Bolivia.
Congress wound up passing a joint resolution to try to keep American manufacturers from selling weaponry to the belligerents down in South America. But the resolution didn't actually ban the sale of weapons. It merely said that the President of the United States would have the power to ban them if he chose to do so. And just a couple days after Congress passed that resolution, President Franklin Roosevelt used his power under it to ban the sale of weapons to Bolivia and Paraguay. After the ban took effect, the Curtiss-Wright Company got into trouble for trying to smuggle some aircraft with machine guns on them down to Bolivia. The company's defense was that the president's proclamation banning the sale of arms to these countries was unconstitutional. Again, Congress had not banned such sales. Instead, Congress had authorized the president to decide whether to impose such a ban. In other words, Congress had delegated authority to the president to handle this issue. There is a rule of constitutional law called the non-delegation doctrine. For example, in the Schechter poultry or sick chicken case, Congress had empowered a poultry industry association to issue a code covering all sorts of business practices for the poultry business. And the Supreme Court struck that down as being an excessive delegation of Congress's legislative authority. They said that Congress is supposed to have the legislative power, and it can't just give it away to someone else. That decision was in 1935, just a year before the Curtiss-Wright case came along. Now, in the long run, the non-delegation doctrine turned out to be fairly weak, and today nothing ever really gets struck down under it. The Supreme Court now lets Congress delegate lots of authority, as long as there's some direction or guidance about what is supposed to be done with the power. But at this time, in 1935, 1936, the non-delegation doctrine seemed like a really strong thing. The Supreme Court was using it to strike down important statutes in the context of domestic economic affairs. So the big question was how aggressively they would apply the doctrine here in the context of foreign affairs. Would they say that this joint resolution empowering the president to ban arms sales to the warring South American countries was an excessive delegation of legislative authority? Or would they say that foreign policy matters are really different from domestic ones? Justice Sutherland came down clearly on the side of saying that foreign policy matters are a lot different from domestic policy issues. There are a number of strands to this opinion, but perhaps the most significant thing is Justice Sutherland's discussion of the issue of sovereignty. Sovereignty means the ultimate control. The sovereign is the one who has ultimate authority over a particular territory. John Marshall talked about this in his decision way back in McCulloch versus Maryland, and he emphasized how the framers of the Constitution believed in the idea of popular sovereignty, meaning that the people ultimately are the boss. And that's why the preamble to the Constitution begins, "We the people." It's a nod to the idea that it's the people who are really the ultimate source of authority. But as a practical matter, the people must act through government. So we can ask which government had sovereignty in the early days of this country. In other words, we can try to trace the sovereignty and how it was passed from one set of hands to another. The dominant traditional view prior to this case was basically that sovereignty had passed from the British Crown to the 13 individual American states when they declared their independence. And according to that traditional view, the sovereignty remained there, fully in the hands of the 13 states, even when they got together and adopted the Articles of Confederation. That was such a loose confederation or association that it didn't take away the states' sovereignty. But when the Constitution was adopted, the American states gave up some of their sovereignty to form the new national government, the United States of America. But it still wasn't a complete surrender. It was a limited surrender only for those things listed in the Constitution as being the federal government's enumerated powers. That was the deal, the bargain struck in the creation of the Constitution. The new national government would be superior within its enumerated powers, but it wouldn't be able to do anything except within those enumerated powers. So that is the traditional view of how sovereignty flowed to where it is today. And the key consequence of it for constitutional interpretation is that the federal government's power is supposed to be narrowly construed, so that the federal government gets only what the Constitution specifically gives it, and the rest of the power remains with the states. However, in this Curtiss-Wright opinion, Justice Sutherland disagrees to some extent with that vision of the flow of sovereignty. He says that's all fine and true for domestic issues, but for foreign affairs, it was a different story. In Sutherland's view, the 13 separate states never had sovereignty in the sense of international law or foreign matters. The sovereignty over foreign affairs was never fragmented into the separate hands of the individual states. Instead, the sovereignty over foreign affairs was immediately taken over by the United States of America, meaning the union or collective combination of all the states. And in Sutherland's view, this makes a big difference between the nature of the national government's authority over internal or domestic matters versus external or foreign affairs. For domestic matters, the national government's power is limited to the things that are enumerated in the Constitution. But for foreign policy, the national government has the full inherent powers of a sovereign, and it doesn't really matter what the Constitution says. Now, Sutherland's argument is meant to be an assertion about historical facts, not just theoretical concepts. He offered historical evidence about the wording of key documents and about the way in which foreign affairs was handled in those early days of the United States' existence. For example, he pointed to the text of the Declaration of Independence. It referred to the United States of America, and it talked about the United States of America having the power to do foreign policy things like levying war, making peace, and making alliances. And so Sutherland felt that the wording of the Declaration of Independence was significant, and it's talking about the United States of America in a more singular or collective sort of way. For example, they could have listed the names of all 13 states, New Hampshire, Massachusetts, and so on, and said that each of them now had the power to declare war, or each of them now had the power to form alliances with other countries and to conduct international commerce, but it wasn't phrased that way. And then Sutherland pointed more broadly to the way things were handled for foreign policy in that era. He said that the colonies always acted as a unit in foreign affairs, acting through a common agency, the Continental Congress. It was the Continental Congress, one centralized authority, that exercised the powers to declare war and peace and raise an army and a navy. Sutherland says this was true both before the Declaration of Independence and in the decade after it. And he talked about the wording of another document, the Treaty of Paris, which was the treaty with Great Britain in 1783 that ended America's Revolutionary War. It was a treaty between the British King and the United States of America. Again, it wasn't a treaty between the British King and New Hampshire and Massachusetts and Connecticut and Rhode Island and so on. It was a treaty between two parties, Britain and America, not between Britain and 13 separate states. And Sutherland felt that that was more proof that sovereignty over foreign affairs was consolidated in one union even before the Constitution was adopted. So, Sutherland has this very interesting and very historically oriented argument about the nature of authority over foreign affairs in early America, and his conclusion is that sovereignty over foreign affairs went straight from the British Crown to the United States of America even before the Constitution was ever written. And so, the national government's authority over foreign affairs is not dependent on the Constitution, and it's not limited to the things enumerated in the Constitution, and it's just not subject to the same restrictions that the Constitution imposes on lawmaking and policymaking for domestic issues. Sutherland's version of history has the result of putting all the authority over foreign affairs in the hands of the federal government as opposed to the states. And as far as the federal government goes, he leans heavily in favor of presidential power. He quotes a famous remark from John Marshall in 1800. At this point, John Marshall was a member of Congress. It was before he became the Chief Justice of the U.S. Supreme Court. And Marshall said that the president is the sole organ of the nation in its external relations. So Sutherland uses that quotation as further support for his very federal-centered and presidential-centered view of foreign policy matters. Now, everything that Sutherland said in the case has been exhaustively critiqued and hotly disputed. For example, some people say that Sutherland is wrong about the history. They go back and point to historical examples from the period between 1776 and 1787, where the states did in fact exercise power in international matters. And others have criticized Sutherland's opinion by pointing out that the Constitution specifically gives the federal government some foreign affairs powers. Article 1 gives the Congress the power to regulate foreign commerce and to declare war and to regulate the Army and the Navy. Article 2 gives the President the power to receive ambassadors and to be commander-in-chief of the military. And the President and the Senate together have the power to make treaties and to appoint ambassadors. So people point to those things and they say, gee, this sure doesn't seem to be something that was written by people who believed in the national government having some sort of complete, inherent, unspecified power over foreign affairs. It sure seems like they went to the trouble of spelling out all of these particular grants of foreign policy power. And it doesn't seem like they would have bothered to do that if they believed the national government just inherently had always had and would always have broad, unenumerated authority to do anything and everything with respect to foreign affairs. So Sutherland's opinion has been criticized by some observers, but it has been extremely influential. The Supreme Court always cites it when they want to sustain a broad interpretation of the federal government's powers over foreign affairs, and in particular, when they want to uphold a broad delegation of power to the president with respect to foreign matters. The opinion makes clear that constitutional law is different in the realm of foreign affairs, and the rules that apply to domestic matters don't necessarily apply at all when you're talking about foreign relations. The bottom line in the Curtiss-Wright case was that they did uphold the charges against the manufacturer for selling the machine guns to Bolivia. By the time the Supreme Court's decision was made, the war in South America that had given rise to the decision had already ended. Both countries, Bolivia and Paraguay, were exhausted from the war and decided to call a truce.
An armistice has at last stopped the desperate war in the Gran Chaco, which the unfortunate combatants call the Green Hell.
The bitter twist was that the region they were fighting over actually didn't have any oil, so the war had been a very big, costly mistake. But the Supreme Court's decision in the Curtiss-Wright case soon had important consequences. This was decided in 1936, and trouble was brewing in other parts of the world. Hitler had come to power in Germany. Italy invaded Ethiopia. A civil war started in Spain. Germany, Italy, and Japan formed an alliance. So there was all sorts of trouble on the horizon. And at that point, the overwhelming sentiment in America was that the United States should stay out of it. The most popular view, by far, was neutrality, isolationism, non-intervention. And so, because of the Curtiss-Wright decision, Congress was able to delegate a lot of authority to the president to act quickly to keep America out of trouble and shut down the supply of weapons to particular countries. For example, when Italy invaded Ethiopia, President Roosevelt promptly imposed an arms embargo on the countries involved in that conflict. And then, as the United States drifted closer to involvement in the World War, Congress started using this sort of arrangement to empower the president to go the other way and get the U.S. involved in the war. For example, in 1941, Congress passed the Lend-Lease Act, which said that the United States could start supplying tons of equipment to aid Great Britain and its allies in their war efforts. And that statute delegated huge amounts of authority and discretion to the president to handle the details of that distribution of aid. And when the Germans invaded the Soviet Union in June of 1941, the Soviets suddenly became our ally, and they were in big trouble. The German offensive into their territory was very successful at first and threatening to knock out Soviet resistance. President Roosevelt was able to immediately start supplying vital military equipment to the Soviet Union without waiting for Congress to approve it. So those were situations where the Curtiss-Wright precedent got applied in extremely important ways.